Probably the primary characteristic of all the changes that are going on in government right now is how fast everything is happening. We've commented in several videos on that previously, and that hasn't changed. If anything, the process has speeded up. Of course, one of the pressure points that's coming about for the federal workforce is whether to accept or reject the deferred resignation policies and program that have been put in place and that expires February 6th. So it's coming up fast. As we mentioned in another video, there's a carrot and a stick approach being taken by the administration. The carrot, obviously, is deferred resignation. There's some factors in there that a lot of people would like, including you can work at home, or if for many cases you wouldn't have to work at all, but you still get paid through September 30th, the end of the fiscal year, which is, of course, the plan. It's very convenient administratively to have this plan end on the very end of the fiscal year, if that makes sense. Another part of the stick is telework. A lot of people for months now have been saying they like telework. They prefer working at home instead of going into an office, and giving various reasons, including I'm more productive at home than I am in an office. I don't waste so much time in meetings. I don't have to drive. I'm not tearing up the roads. I'm not contributing to the congestion in a big city, et cetera, et cetera. So it's obviously very important to many people. But another event has now occurred, very recently, regarding telework. Last week, late Friday night actually, the president issued a memo, and it was entitled, Limiting Lame Duck Collective Bargaining Agreements That Improperly Attempt to Constrain the New President. Well, from the title itself, you can tell that he was not favorably inclined toward the collective bargaining agreements that have come up that are trying to constrain his ability to end telework. And what happened is at the end of the Biden administration, typically after the election, a number of agencies apparently negotiated contracts with unions representing bargaining unit employees in that agency that allowed them to continue telework under the existing policies until at the end of the Trump administration in 2029. And what this executive order said that came out, or this actually was a memo, not an executive order, is that's not going to happen. As typically happens in government, after the president issues a memo or an executive order, OPM often issues guidance telling agencies how to implement this new guidance that they have been given by the president. That's what happened in this case. OPM has now issued that guidance, and that concerns telework and will you be able to continue using telework if you're already on that kind of a program, especially with regard to using telework as a result of or the benefit of a collective bargaining agreement that gives you that right. In a nutshell, this is my phraseology. It's not OPM's. What the OPM memo says is forget about it. It's not going to happen. There are exceptions, of course, but that would be very limited and not apply to most of the people now on telework. So this is the stick part, trying to get people to resign to reduce the size of the federal workforce. So the OPM memo says it makes these points in defense of its position on the issue. And this gets down into labor relations case law, labor relations law itself, a labor relations statute, and how it's been interpreted and applied in the past. Now, there's something in the labor relations statute called management rights. That's just interpreted differently at different times by different administrations, by courts, by the Federal Labor Relations Authority. And in effect, what is happening now is OPM is defining the term management rights, and specifically as it relates to telework. So they make several points that affect you and your ability to engage in telework. It says telework levels and exclusions of positions from telework are reserved as a management right. In other words, they're saying your agency has the right to decide which positions can be using telework and which positions cannot use telework. FLRA precedent, that's the Federal Labor Relations Authority, indicates management rights include the right to determine the frequency of telework. Now, they're referring to past decisions decisions that have been issued in past years, not something that's come about as a result of the current issue that you're concerned about now. An agency also has the right to exclude positions from telework. So they're making the point, if your agency says your job is such that we can't have you on telework, that's their right to make that decision. The union contract doesn't control it. Labor agreements that conflict with management rights are unlawful and cannot be enforced. And finally, even if the agency head has approved a contract, unlawful provisions of a contract still cannot be enforced. So what the President's memo, the OPM guidance, are working together to say, in effect, your agency has the right to decide whether or not you can engage in telework. In other words, can you stay at home and work there instead of going back to the office, wherever that may be? The collective bargaining agreements that are negotiated, have been negotiated, according to President Trump, were designed to allow employees to continue using telework. What this series, the President's memo, the OPM guidance, are saying is that these collective bargaining agreements are not enforceable. Even if the agency had approved it, especially those that were approved prior to the Trump administration taking office, are not enforceable. We're going to ignore it. We're not going to allow that contract to stop us from limiting the use of telework in the government. So now, in effect, OPM has laid down the law, so to speak, on this issue. And most people who are now using telework are not going to be able to in the near future. The program is evolving so that you've got a chance taking deferred resignation program, use that if you want. Or if you stay at work, then you're probably not going to be able to stay at home. If the agency gives you a direct order to come to work in the office effective next Monday, then that would be your obligation to meet that and show up at work. If you don't, then you can find yourself subject to termination. And I suspect that's going to happen at some points in the government. What's likely to happen, AFGE and other unions are coming out, and of course they don't agree with it. Their position is, we negotiated these contracts, we negotiated it with management of the various agencies. These were put into place as allowed by the Civil Service Reform Act of 1978 under the labor relations portion of that law. And we intend to get this to be enforced. This is going to be enforced, and we're going to fight it. They'll probably end up first going to the Federal Labor Relations Authority. That's the agency that typically resolves labor disputes like this. One problem, the General Counsel of the Federal Labor Relations Authority, that position is empty. That position has been empty since 2017. How or why doesn't make much difference. The fact is that's now 8 years that there hasn't been a general counsel at the FLRA, or 7.5 years. The Federal Labor Relations Authority can't issue an unfair labor practice if there's no general counsel in the office. For a while under President Biden, there was an acting general counsel. The GAO came in and told the FLRA, this is illegal, this person has been in the job too long, it violates the law. And nobody has since been confirmed by the Senate to take over that position. So usually the unions would go to the Federal Labor Relations Authority and say, this agency is violating the labor relations statute, and we want you to issue an unfair labor practice, and as a remedy for this, you should direct the agency to allow employees to go back to telework as outlined in their collective bargaining agreement. But since the FLRA can't issue unfair labor practices, that's going to be a problem. That doesn't stop the unions from filing an unfair labor practice. It does probably result in not going very far for a period of time. That doesn't stop the unions from going into court, and my guess is they will. And they'll probably ask for a court to issue a requirement that the agency allow people to go back to using telework because of the collective bargaining agreement. I don't think anybody knows how that will come out. The government will, probably the Department of Justice will, if that goes to court, defend what the agencies are doing, what the president and what OPM have provided guidance on. The unions will make the opposite argument that what we are doing and what the employees are doing are completely legal, and what they're doing, the government, is illegal, and we want you to put a stop to it. So that's where we stand. For those of you who've been around a little while, you may remember that the Merit Systems Protection Board went through a similar process, again back in 2017. There wasn't a quorum at the MSPB, so all the employees' appeals that would normally go to the MSPB still went there, but no decisions were issued. Without a quorum, they couldn't issue a decision. By the time the MSPB got a quorum, there was something like 3,600 cases piled up, and they're still unraveling from that. And it's taken quite some time. It seems to me that this is a similar situation because you've got an agency, MSPB in one case, FLRA in the other case, that doesn't have a full quorum. It doesn't have all the positions that need to be filled so it can carry out its job, what its mission is. Congress can fix that. They can confirm a general counsel if one is nominated. Now, to my knowledge, President Trump hasn't nominated one. And if, to be Machiavellian about it, if you don't want the FLRA to be able to file or to issue unfair labor practice decisions, why would he nominate somebody? The approach may end up being, let's not nominate a general counsel, let's just let this play out. In the meantime, you can't go back to work. Using telework, you'd have to go into the office. We don't know how this is going to play out. We do know that it's an issue that affects a lot of people. There's a lot of emotion behind it. People are raising arguments. There's not enough government space because we haven't been using the buildings. GSA has terminated some leases, etc. We don't know exactly what the plan is. Presumably, just from looking at it from a third-party standpoint, the government is trying to get rid of a bunch of people. Maybe that's part of the plan. We'll see as events occur. FedSmith will keep providing you information as it becomes available. In the meantime, we wish you the best of luck in making a decision that's right for you under the Deferred Resignation Plan. Thank you for watching, and good luck in making the right decision.